Politicians love talking about regulating frontier AI, but when it's time to pass a law, the process stalls out in endless hearings and tech lobbying. Because of legislative gridlock, the rules governing artificial intelligence aren't being debated on the House floor. They are being quietly drafted in the margins, using private agency letters and obscure procedural technicalities. To actually write the rules for frontier AI right now, you don't have to win a public political debate. You just have to know how to read and manipulate the statutory clock. We can see this operating clearly at the state level. In Hawaii, State Senator Jarrett Keokalole introduced SB 3001, a bill requiring conversational AI chatbots to disclose to minors that they aren't human. Knowing the tech lobby would oppose the mandate, Keokalole drafted the text defensively. He worked directly with the state attorney general to harden the language against the inevitable lawsuits before they were even filed. This diagram shows the mechanism Keokalole relied on next. Instead of lobbying for a signature, he used Article 3, Section 16 of the Hawaii Constitution, which triggers a 45-day countdown for bills passed near adjournment. To block it, the governor must issue an official intent-to-veto. On June 25th, Governor Josh Green published his official intent-to-veto list for the year. He listed 4 specific bills. SB 3001 was clearly not among them. Because the governor kept SB 3001 off that list and said nothing, the 45-day clock expired on July 15th, automatically making the bill law. By holding the legislative clock and letting the time run out, calculated silence finally finished the legislative work. In the federal executive branch, the mechanics of time work differently. When a government agency acts unilaterally and in secret, a passive wait won't work. On June 12th, the Bureau of Industry and Security abruptly restricted access to 2 of Anthropic's frontier AI models, Fable 5 and Mythos 5. The agency didn't publish a public rule or post a notice in the Federal Register. They executed the export control entirely through a private letter sent directly to the company. When an agency governs by private correspondence, it creates an arbitrary timeline where AI dependencies can be shut off instantly. Downstream businesses building on those models are left exposed, with zero warning. Arthur Rothrock is a California litigator and the CEO of a startup called Legion Legal Tech. His software relies on the Fable 5 model to draft legal documents, so the sudden restriction threatened his company's ability to operate. Rather than waiting for an industry coalition to form or politely asking the agency for an explanation, Rothrock used the legal clock. On June 23rd, 11 days after the restriction, he filed a federal lawsuit. This diagram illustrates what that filing accomplishes. By submitting an Administrative Procedure Act challenge, Case 1.26-CV-02225 before Judge Richard Leon, he forces the dispute out of a closed loop of private agency action and onto a strict federal docket, locking the dates into place. By paying the filing fee, one customer turned a private executive directive into a public federal docket. The clock now belongs to the court, legally compelling the government to explain its statutory authority for frontier AI export controls on the record. The final institutional arena is the United States Congress, where a group of lawmakers tried to question the exact same restriction on Anthropic. Representative Sam Liccardo led a bipartisan coalition in sending an oversight letter directly to Commerce Secretary Howard Lutnick. The letter laid out 8 specific questions, demanding the legal and statutory basis for the export control. The representatives placed a specific constraint on their request. They demanded a written reply from the agency by Friday, June 26th. Friday came and went. The congressional deadline expired, and the Commerce Department delivered absolute silence. The silence wasn't due to a lack of time. On the exact morning the congressional deadline expired, Secretary Lutnick wrote a separate private letter to Anthropic, partially clearing the restricted models for specific users. The executive agency made time to privately grant a waiver to the regulated tech company, but chose to completely ignore the congressional deadline. A signed letter from a House member is a political clock. It lacks the hard compulsion of a state statute or a federal judge. Right now, the rules for American AI are being negotiated in private agency correspondence, and the only actors actually shaping them are the ones pulling the strict, unignorable levers of time.